All right, we're back on the record in State v. Jarrett Berg Smith, case number 20 CT 777. And the court reserved ruling on the state's motion to disallow the defense from discussing inoperability at closing. Did I state that sufficiently?
Yes, Your Honor.
All right, and you've provided us with Jones v. State, 510 Southern 2nd, 1147 out of the 1st District. Hughes v. State, 943 Southern 2nd, 176 out of the 3rd District. And 36 Wash App 439 out of the Court of Appeals in Washington State. The State v. Smelter. Mr. Webb, do you have any additional argument that you'd like to provide, or shall I go to Ms. Armpriester?
Your Honor, you can go to Ms. Armpriester.
All right, Ms. Armpriester.
Your Honor,
You may.
in looking at the state, but I don't believe this applies. This was a commercial pilot out of New County. Who was charged with operating an aircraft while intoxicated or in a reckless manner. And in this case, I just don't even if you look at the congressional intent and legislative intent, the facts are not anyway similar. This is a very lengthy case, approximately 20 pages, and seeing that the issues and the facts of the case involving Mr. Hughes include that of a commercial airline pilot who was working under a different duty. There was also a DUI in this matter. There was blood alcohol, not correct. It should have been something that applied either way as opposed to inoperability. The defense is not trying to argue what the state is getting at. They are trying to argue the instruction in the law as it is written in the jury instruction.
All right. Let's take each case one at a time. So let me just state, Ms. Armpriester, it appears that Hughes v. State was brought to the court's attention because of its analogy to DUIs, specifically found beginning on page 193 or page 15 of the copy, in which they discuss the defense of inoperability, which is based on a premise that a person ought not to be convicted of having a vehicle under his or her control while intoxicated, when in fact the vehicle was inoperable. The intoxicated person did not operate the vehicle prior to its becoming disabled, and the vehicle's mechanical problems were such that it could not, under reasonable circumstances, have been operated by the person accused. The difference that I see in our case here today is that we have testimony that Mr. Smith was operating the vehicle before it became inoperable, notably testimony from Mr. Love that Mr. Smith was the driver of the Nissan.
Which is why I'm confused as to why I'm not voting for inoperability. I'm just arguing that and as it relates to the car, the way that the trooper described it, and I believe it's a question for the jury, but the car did have to be towed away. And actual physical control on page 193 of this case, actual physical control of the vehicle means the defendant must be physically in or on the vehicle and have the capability to operate the vehicle regardless of whether he is actually operating it at the time. That's a question for the jury.
Right.
Law enforcement can contact.
I'm well aware of the definition of actual physical control of a vehicle, but what I'm looking at is the definition of the defense of inoperability. Because wouldn't that be your argument, that the vehicle was inoperable?
Yes, but that's not my main defense, and that's not.
I understand, but it's a defense to one of the elements.
I guess what I don't understand is if I can't go over the definition that the court's aware of, that I'm aware of with the jury, That's all I'm going to do. So I'm not sure what the state's attempting to preclude me from doing.
I think what the state is trying to preclude you from doing is arguing an inoperability defense.
And I don't know why they're...
Based on the defense of inoperability, the definition, a person ought not to be convicted, and then it goes on, the intoxicated person did not operate the vehicle prior to its becoming disabled. That's not what we have here. And, keyword and, the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated by the person accused. It was being operated before, according to the facts that we have before us.
Prior to, however, it was not operable after. When the state made the argument and the questions, I believe it was along the line of questioning of why didn't he call 911, why didn't he pull over? The car could not drive, could not move. After the incident, it was in fact inoperable.
It's not, here's Mr. Reb, the defense of inoperability, the definition, did not operate prior to and not capable. Let me rephrase that. Did not operate prior to the disabled vehicle becoming disabled, and the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated by the person accused. We don't have the facts for number 2 in evidence, other than it was out of gas. And we know that we have facts and evidence that he was driving it before it was inoperable. So the defense of inoperability is not available to you, based on the facts that were presented in court.
And I never asked to have the inoperability because Mr. Rob assumed that it was going to make it. I'm not going to argue inoperability. I'm simply going to go over actual physical control and its definition and apply it to the facts of this case. I never have said or gone on record that I'm using inoperability as a defense. But I would like to be able to state after the incident that the vehicle was inoperable and had to be towed away.
Don't you think that's going to, isn't that arguing the defense of inoperability?
Your Honor, the jury is not lawyers who are well aware of the definition of inoperability. The officer stated that when he arrived, the vehicle was inoperable and had to be towed away. And that goes to the severity of the accident.
I'll also note that the other case that the state provided to the court in Jones v. State, the court found that the defendant could not be convicted of driving under the influence when the defendant was found slumped over the wheel of a car stopped on a shoulder of public road. In light of evidence that the vehicle was inoperable, defendant did not operate the vehicle prior to its becoming disabled, and the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated. Again, we don't have that in our case either, Ms. Armpriester.
Your Honor, I've never once asked to make the defense of inoperability, so I don't.
That's what you've argued that you're going to discuss, though.
Well, I can find a synonym for inoperable. The car wasn't drivable; it had to be towed away. That was all testified to. If I'm not allowed to discuss in my closing argument what was testified to by the cop, then.
Your Honor, if I may.
Go ahead.
Just for the record, it was brought to the court's attention in the second case that Ms. Armbrister did argue that the vehicle was effectively inoperable. Therefore it did not meet prong 1 or element number 1. So my assumption, again, Your Honor, is that Ms. Armbrister is going to use that in her argument in closing. And that is why the state requested that the court make a ruling on that matter.
Your Honor, this could have, the last 2 hours seemingly could have been avoided if we had, the state and I had a conversation about it. What I argued in JOA, Your Honor ruled on me denied. So certainly was not involved in that security, and I made that argument outside of security.
All right, thank you, Evelyn. State's motion is granted, and in light of that granting of the motion, Madam Clerk, here's the case law the state provided for that motion. Because jury instruction 28.1 states give, if applicable, the definition of actual physical control of vehicle, I don't believe that it's necessary for this case.
The actual physical control?
The definition of actual physical control, I don't believe is necessary to include in the jury instruction, given the court's ruling.
But